So today we're covering direct examinations and using exhibits, incorporating exhibits into our direct examinations. And the thing that we want to introduce as it relates to these two topics. Direct examinations is that part of the case that you, as the proponent, you, as the one putting on a case, put together. When you are talking about a direct examination, you're talking about an examination of your witness, someone you invited to the party, someone you thought that their testimony was going to contribute to your case and your case presentation in some way. And it usually goes along with, and I like to think about it as we are thinking about their testimony over here, what they will add to the case by the words that come out of their mouth, by the questions that we ask, but also what exhibits at the same time do they sponsor, right? It's the testimony they give and the exhibits that they sponsor. And we're going to talk about why that's important. But I almost envision, and I prepare my cases, particularly as a prosecutor or when you're going through document-heavy civil cases, I prepare them almost as a matrix of witness name, bullets of witnesses' testimony, and exhibits that they will sponsor. I need to understand when I call my 10 witnesses, my 4 witnesses, my 40 witnesses, what are the parts, what are the testimony they're going to offer, what is the testimony they're going to offer, and what exhibits are going to come in through which witness. Okay, so I plan out my case in this way. And we're focusing on today when we call that single witness and how are we going to conduct the direct examination of that witness. So we'll recognize that it's part of an overall case presentation, recognize that it's part of an overall case plan, but then when you get that next witness on the stand, when you're going to ask questions, when you're going to host this conversation. Now I start out my trial advocacy course, and I know those of you that are in it know this, but I start out my trial advocacy course by presenting, one of us in class presents another person in class. And we present by way of arguing about them, giving a jury address about the other student, but we also present the other person in class and introduce the other person in class through question and answer. And that's the way you should start to think about direct examination. Imagine that you're presenting your best friend. Imagine that you're presenting someone that you have intimate knowledge of their background and what they contribute to your case. Knowing that person, how can you host this conversation? You know what you want out of them, you know where they come from, and you know who they are. How do you present that conversation? So if you think about people on TV and in the movies that are very good at the interview, you know, the presentation type interview on talk radio, think of the ones that are very good. They are doing what we're asking you to think about for direct examination. They are hosting this conversation. They're fading to the background a little bit with where they stand and the questions they ask. Less words come out of their mouth, and they're really just facilitating and hosting this conversation with this subject that they know very well. So think about it that way, right? It's not this stiff exchange of, and then what happened? It's what everyone thinks prosecutors do, right? What happened next? And what happened next? And what happened next? No, that's not hosting a conversation. That's just you putting in a question once in a while the witness talks. Hosting a conversation is knowing exactly what you want from this person and actually steering the conversation and guiding the conversation to hit efficiently the points that you want to cover on direct. Here's a couple of things that we want to talk about. Focus on your witness and their story, right? We're called this witness because they have something to contribute. I've planned to have this witness as part of my case because I know what they add. And they add something to my overall presentation of the story of my side of the case, my theory of the case, and my case presentation at trial. So don't worry about the whole picture. Don't worry about the broad picture of your case. Worry about this witness's contribution to the story. And tell it like a story. You're talking about it, and it's a new skill, and it's a new skill for a lot of you, to sort of let the microphone be shared with someone else and tell this story through question and answer. It's something that we get comfortable with by way of presentations, that we're going to stand up and say, this is a case about this, and now I get to give an opening where I talk for 5 minutes and tell you what this case is about. It's a different skill entirely to fade to the background a little bit and ask questions from a character in the story to describe the story. So get comfortable with that. Get comfortable with hosting this conversation and asking questions to a witness that knows. This is my little phrase of how I sort of sum up what direct examination is. It's a sequential flow of open-ended questions to tell the story. That is, it should be sequential. There should be an order to it. Direct exams are not the time to jump around and say, I'll piece it all together later. It should be a flow. You should actually kind of, for the listener, or from the listener's perspective, it should be a little bit effortless. You should get to sit there and say, oh, I see how these questions relate to another. Oh, we're going in chronological order. Oh, we're actually going on this search with these agents, and we're starting at the front door of the house and then we're going into the living room, I appreciate the order and the flow of these questions and these topics from one to the next. You are asking open-ended questions. There are times on direct and under the rules where you can ask leading questions and you can move it along with leading questions, but really the object of direct examination is to have the witnesses the answers come from the witness's mouth. I want the witness to be talking. I'm hosting, I'm steering the conversation, I'm deciding which topic's next and how we're going to frame the conversation, but the one that the jury should be focusing on is my witness. I want them to believe my witness, and Brian's going to talk a little bit about crediting the witness so that they're believable, so when we get to the good stuff, that they're already on your side and they already trust your witness and they already want to believe what that witness has to offer. And above all, and I'm going to repeat this, you're going to see this in a bunch of slides, tell the story through this witness. You've already presumably stood up an opening, or your trial partner has stood up an opening and kind of captioned this case in the form of a story. Now, through question and answer, now let's get this witness to contribute to the story, right? It can come off sounding like what happened next, but with more direction and more hosting from you of what happened next and where are we going next, right? And you do that, let's look at this one statement. You do that by establishing the order in the organization. You do that by using some transitions and some techniques. One technique is called looping, right? Those of folks in my trial act classes heard what I don't like in response to a question when you just put the answer back, something that we call echoing. Where'd you go on that day? I went to the store. You went to the store. And when did you go in the store? At 4 o'clock. At 4 o'clock, right? That's echoing. That's bad, right? But looping is a technique where we can actually take your answer and it feels like a real conversation that we may have on a sidewalk, right? When did you go to the store? At 4. And upon getting to the store, where did you go first? I went back to the drink aisle. Did you select a drink? You know, it actually flows into each other, and I've looped in part of the answer to my next question, so it sounds like a regular conversation. And more importantly, actually proves to my jury, who should be listening, that I'm listening. I can't tell you how many times, especially law students and new trial attorneys, start out with a direct examination, and they get 2 answers for the price of 1. It's, where did you go to school? Oh, I went to school at Palo Alto High School and I graduated in 1978. When did you graduate? You know, you just got that answer. If you were listening, you'd realize you just got 2 for the price of 1 and you have to move on. So listen to answers and host this conversation instead of being married to where you have to go next. The open-ended question part is just the way that you sort of steer them where you want to go, but you make sure that your words aren't the ones winning out. You were angry that day then? Can you describe that? No, angry is your word, right? How did you feel that day upon receiving the news? Now you've opened it up and everyone's going to focus on the witness. The jury's attention is going to slide to the witness. Everyone wants to hear how they felt that day. They don't want to hear you, attorney, saying, give us the degree of angry that you felt that day. See what I'm saying? So the words come from the witness and you then hear it and use it into your next question, use it to go. The other technique that we use for flow and during open-ended question is something called signposts. You can use these kind of introductory clauses to your question to direct your witness to a different part in the timeline or maybe a different part in the geography. So signposts are really effective because even though this case may have spanned 3 years, I don't need to cover every day in those 3 years with the same degree of attention, right? I just covered this day, and this day was important to my story and this witness's contribution to the story. But now, guess what? The next important detail is 1.5 years off. It's time to fast forward. And the way we fast forward when I host a conversation in direct is moving forward to 1999. Where were you working at that time? Notice the moving forward to 1999 is a clause. I've decided in hosting this conversation that we're going ahead in the timeline to 1999. Same thing as if I was doing it with geography. When you first got to the street, where did you go? I went to the block, this end of the block on Miller Street, 132. Did you move down Miller Street as it went on? Yes, I did. Moving your attention all the way until you were done with Miller Street, what street did you go next? Notice I moved them along in the geography. Nothing else was important on Miller Street, so I moved along in the geography. So from my perspective, signposts are effective when they move you ahead or behind in a timeline, or when they move you around in a geographical space. You'll find, new trial attorneys, one of the mistakes that you make is that you want to add transitions to everything. You want to add signposts to everything. I'd like to ask you some questions about the surgery that you had on January 14th. Did you have a surgery on January 14th, right? Notice that signpost doesn't do us any good. That signpost just directed us to a question where the question would have done the same thing. Oh, apparently we're talking about a specific surgery on a specific day. Okay, so use these things to move us around. And just like everything else, is a good faith test to this, right? You can't weasel inappropriate stuff into a signpost. Now, understanding you were angry and you well should have been because of this awful thing that happened to you, where did you go after you left the store, right? That's not a signpost. That's an editorial. That's a soliloquy, right? We don't want those. We want places where you can direct them along that shows that you're listening and you're guiding this conversation through this witness.